Hello, I'm Attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin Kerrigan, and I've been practicing here in New Hampshire for about 39 years at Hamlin Kerrigan, about 38 years for there. I clerked for the courts for 1 year before coming here. And in the Commonwealth of Massachusetts, I've been actively practicing also for about 28, 29 years. I've done a lot of business contracts, and I represent a lot of businesses in a variety of issues from everything from professionals like accountants, lawyers, and medical profession to universities to manufacturing, high-tech, low-tech, service industries, all those industries. And I've negotiated quite a few contracts. And today I'm just going to be focusing in on the importance of making sure everything you want into the contract is in the contract itself. We generally have a law in New Hampshire and Massachusetts and across the nation that there's something called the parol evidence rule, which basically the courts are going to look at the actual contract itself, and if they can understand the contract by looking at the contract, they're not going to take what they call extrinsic evidence, stuff outside the contract, to deal with it. And also, usually you'll have right in the contract itself what we call the boilerplate provisions, integration clause, saying everything that you dealt with before, all the discussions you had before, if it's not in the contract, it doesn't exist. So let me go through that detail in this vlog. So we start off with the concept in any type of contracts that if you want it in the contract, you should put it in the contract. If you ever hear somebody that says something like, we would never do that to you, but this is the standard provisions of our contract, and you have emails that are saying the same thing during that period of time, don't sign the contract unless it specifically says what you've agreed to say. Because there's general proposition, if it isn't in the contract and the judge can, or the arbitrator, whoever's deciding the case for you in a dispute, can't understand or can look at the contract and understand it directly, and it's talking about that topic, the fact that you've had other emails or texts say, well, wait a minute here, I have some text that show something different, you are in a bad situation trying to enforce that. It's more likely than not that the judge is going to say, well, this is your final agreement, this is what you ultimately dealt with, particularly if you have what I just talked about a few minutes ago, or a minute or so ago, about the integration clause. And even if you don't have that, don't rely on those previous emails to see, well, we're negotiating that, because if you don't have it right in the contract, it's not going to be there. New Hampshire's rules of construction of contracts, meaning what they do for interpretation, is they will only take outside evidence, extrinsic evidence, also called parol evidence under the law, if there's an ambiguity in the contract. So if the contract, in looking at it, could be subject to two different interpretations, then in that situation, the court might take outside evidence, and then you might say, well, this email says we were supposed to agree to that, and the other person says, well, this email actually says, or maybe another email says, we're supposed to agree to this, and then you have a conflict between each other. What I tend to do to avoid all those issues, and I force the issue on the other side when they don't like it, irrespective if they want to deal with me, is I'll do a for example provision in anything that's complex. So say you're dealing with an executive with a bonus structure, and you set forth a formula, and you want to make sure, or a lease, or anything else you're dealing with, commercial lease, and there's a formula there to determine what the rent is, or the bonus is, or something else that's important in the contract, but you want to make sure that it's not subject to interpretation. I do, for example, if these situations happen, then this is the result. And then, but if these situations happen, these exceptions to this, then this is the result. And I explain that really clean in a for example clause when there's anything, and that will remove the possibility of ambiguity, because you don't want ambiguity in a contract. I've had some people before say, well, let's keep that vague. Why would you want it vague? Good fences make good neighbors. Good contracts make good business partners. You want a good relationship with this person. You don't want to leave something out on the table to fight about later. If you're fighting, the relationship is going to be tarnished. So you want to deal with those. So I've dealt with those issues quite a bit. I always generally, for one, want to make sure that the contract is enforceable as it is, and it's unambiguous, meaning it's very clear to read in plain English. Don't talk up here at somebody. Talk in regular plain English so people can understand it. And then secondly, I generally will put in, except for very, very simple contracts, I'll put in this integration clause that makes it crystal clear to everyone that any emails, any texts, any other oral conversations you had before, to induce people to get into the contract, but it's not in the contract. It doesn't exist. And even if you don't have that provision in there, I'm telling you that the parole evidence rule in New Hampshire and in Massachusetts and across the nation basically says that if the court can read it and it covers that topic and they understand the contract by just reading that contract, they're not going to take outside evidence, meaning those previous emails or what you guys discussed to get to that contract. So put it all in writing, make sure it's in the contract. And if you have any questions, I'm at 603-883-5501, 603-883-5501. I've done quite a bit of variety of contracts, and I'm happy to help. You can also check out my blog at naturalaw, all one word, .com, and then check my bio and click there, and you can get onto the YouTube channel. I have weekly vlogs on a variety of topics, and you can review them. Look forward to working with you. The opportunity arises. Thank you.